Good evening, ladies and gentlemen. I want to welcome everyone to this public forum sponsored by the Charlottesville-Albemarle Bar Association for candidates seeking our bar's endorsement for the position of Circuit Court Judge for the 16th Judicial District to fill a vacancy which will occur upon the retirement of Judge Richard Moore in November. The position will be filled by the General Assembly, who will elect the candidate who receives the support of the delegates and senators who serve the jurisdictions in the 16th Circuit, which includes the counties of Albemarle, Greene, Madison, Culpeper, Orange, Louisa, Goochland, Fluvanna, and the city of Charlottesville. All our legislative representatives have been notified of the forum and invited to attend. Because the General Assembly is in session, it may be difficult for them to attend in person, but we hope they will be able to view this remotely. The Judicial Endorsements Committee has been convened for the purpose of evaluating and recommending candidates seeking the judgeship through a process established in the association's bylaws. The members of the committee are Jim Hingley, Albemarle County Commonwealth's Attorney, who is the president-elect of the association and chairs the committee. Abnel Coates, Chief Magistrate of the 16th Magisterial District, who is acting as our timekeeper this evening. Richard Howard Smith, an attorney with Flora Pettit. Brian Slaughter, an attorney with Mickey Hamlet. Lacey Parker, an attorney with the Public Defender's Office. Susan Bumgardner, an attorney for the county of Albemarle. Jerry Greenspan, a pro bono attorney with Hutton Andrews Kurtz. Lewis Martin, an attorney with Martin and Wren. Richard Armstrong, an attorney with Allen and Allen. Doris Geldman, an attorney with Geldman Law. Joe Platania, Commonwealth's attorney for the city of Charlottesville, and me, Bob Downer. I'm a retired General District Court Judge for the 16th Judicial District, and I'll be the moderator this evening. Our candidates this evening are Nina Alice Anthony. She's Senior Assistant Commonwealth's Attorney for the city of Charlottesville. Andre Hakes, a partner attorney with Tucker Griffin Barnes, specializing in criminal defense. And Arishni Pather, a Deputy Commonwealth's Attorney for the city of Charlottesville. The forum for this evening is as follows. The format is going to be as follows. Each candidate will have 2 minutes for an opening statement. Following the opening statements, I will ask each candidate in turn to answer 9 different questions prepared by the committee. The questions have been developed carefully after carefully reviewing suggestions from members of the bar and the public. And I want to express our gratitude to those who submitted suggested questions. You may not hear the question you submitted verbatim, but the committee has strived to include all of the subject matter covered by the suggested questions in the 9 questions that will be put to the candidates this evening. After the 9 questions, each candidate will have 2 minutes to respond to each question. After the 9 questions have been answered by the candidates, each candidate will have 2 minutes to make a closing statement. Abnel Coates, our timekeeper, will signal the candidates when there are 30 seconds remaining, then 15 seconds remaining for them to speak when making their statements and responding to questions. We will not be taking any additional questions from the public, and I ask all of you who are present to remain quiet and orderly as possible so that each candidate, the committee, and the public viewing this forum remotely will not be distracted. So we will start things off with Nina Alice Anthony, who will give her opening statement.
Good evening. My name is Nina Elise Anthony, and I've served my community as a prosecutor with the Charlottesville Commonwealth Attorney's Office for the last 10 years, and I currently work there as the violent crime prosecutor. I have always strongly believed that the system of justice in our country, whereby ordinary citizens can bring their grievances to court, ask a court to render a decision and accept that decision, even when a lot of times it's against their own interest, is simply remarkable. And I think that system needs a strong guardian, and that's what I believe a judge is and should be. A good judge is someone who is intelligent, fair-minded, patient, humble, and yet at the same time decisive. And I have all of these qualities. As a trial attorney, I have been lead or co-counsel in over 25 jury trials and innumerable bench trials. And through that, I have learned a command of the rules of evidence, a command of trial practice, and both of those are certainly essential for a sitting judge. In fact, I teach evidence statewide to young prosecutors starting their practice, and I teach trial advocacy at the University of Virginia Law School. The reputation that I have earned in the last 10 years in public service is beyond reproach. I am known universally as somebody who is organized, who is thorough, who treats all parties with dignity and respect, and maybe most important for a judge, as somebody who is willing to listen to all sides of an issue before I come to a conclusion on how I should handle a case. All of these qualities make me uniquely qualified for the role of a circuit court judge. And I appreciate the opportunity to come here tonight and talk to you about my qualifications in what I hope will be my continued efforts to serve this community in that capacity.
Thank you, Ms. Anthony. Andre Hakes, I'll call on you for the next opening statement.
Hey folks, I'm Andre Hakes. I am partner at the law firm of Tucker Griffin Barnes. I have lived in Charlottesville since probably right around my 18th birthday. So pretty much my whole adult life here in Charlottesville or the surrounding counties. I lived in Orange. I lived in, I don't know, my first office was in Fluvanna. That's where I practiced initially. I am a UVA grad 93, UVA law grad 96. I have been doing criminal defense throughout the entirety of my career, which is about 25 years of law practice. However, that has become more and more sort of what I do in recent years. Before that, I did a whole bunch of different things early in the first half of my career. I did bankruptcy, I did construction litigation, I did partition suits, adverse possession, guardianship, you name it. I did a condominium case once. So I have a fair amount of experience with civil, not every aspect of it, but a sort of a broad arena of things to draw from. But criminal defense has definitely been sort of where I've landed in the latter half of my career. Tried a lot of juries, tried a number of bench trials, more juries than bench trials probably in circuit court. And this is who I am. I am hoping that maybe I will be qualified for this position. But I guess that's to be determined. So thank you for listening to me. And I hope to have you listen to me a little longer tonight.
All right. Thank you, Ms. Hakes. All right, Ms. Pather, it's your opportunity for an opening statement.
Thank you. My name is Arishni Pather. I'm a prosecutor in the Charlottesville Commonwealth Attorney's Office. I am uniquely situated to be the next circuit court judge in the city of Charlottesville. I have been the Deputy Commonwealth's Attorney in Charlottesville for the last 4 years. I have 18 years of legal experience as a law clerk, public defender, and as a prosecutor. I've worked on both sides of the aisle in high volume offices with high pressure cases. And I've worked as a supervisor, both as a prosecutor and as a public defender. In my 18 years of legal experience, I've tried 24 jury trials, 18 as a prosecutor. These involve the most violent cases, including homicide, sexual assaults, and robbery. The first lesson I learned day one as a public defender was that the court was seeing my client on their worst day. This is a lesson I continue to learn as a prosecutor daily as I help victims navigate the aftermath of trauma. I can't fix what's broken, but a little bit of compassion, kindness, and listening can go far. The court sees the complexities of these two trials sides on a daily basis. And the court has to listen to both sides faithfully and administer a fair and just verdict that is transparent by applying the law to the facts of the case faithfully. I have the background, knowledge, and temperament to serve our district at the highest level of public service. I've devoted my legal career to public service. It is my way of giving back to this great country that has given me and my family so much. I was born in apartheid South Africa, so because of my race, we are considered non-white and we face discrimination. I was lucky enough to emigrate here in 1996 with my mother, and I'll always owe a debt of gratitude to the United States. The court sees people every day who are different, but just because you're different doesn't mean that justice should be different. It should be fair to everyone. I was born in a country without justice that was fair or equal, and I have a chance to serve the judiciary of our district at the highest level.
Thank you, Ms. Pather. Since Ms. Anthony started us off, the first question will be put to Ms. Hakes, and I will continue to rotate through with each question. So Ms. Hakes, first question for all of the candidates is, what are the two most important qualities of a circuit court judge, and how have you demonstrated those qualities in your career?
What are the two most important qualities of a circuit court judge, and how have I demonstrated them? I would say that the two most important qualities, hard to pick two, but I would say probably integrity, doing the job that you've been given with honesty and hard work. And I would also say, respect, treating the people who come into your courtroom like you would want to be treated, affording those people their dignity, no matter in what role they may come before you. In terms of integrity, I like to think I demonstrate it every day that when there's an ethical issue, which arises often in the law, that I do the right thing. If there's, I don't know what else to say about that. As to respect, I would say, one of my philosophies as a criminal defense attorney, I do a lot of cross-examining people on not their best day. And there are people who have potentially been through horrible things. I try to treat those people with as much respect as I possibly can. I still have to make the points I have to make. I have to cross-examine them. I have to try to win my client's case, but I try not to do unnecessary harm. Those are the ways in which I think I have demonstrated those qualities.
Thank you, Ms. Hakes. Ms. Pather?
Thank you. So for me, I think the two most important qualities are fairness and transparency. And fairness to me means that we are engaged in the pursuit of justice. It means that the court is pursuing justice and truth. For me, fairness is about accessibility to the courthouse, no matter your background, no matter your language skills, no matter your socioeconomic status. I remember two cases that I had with victims who did not speak English. And if we hadn't got an interpreter, if we hadn't gotten a language line, they would not have been able to have access to justice. And so the courtroom doors can't close just because somebody is different or someone speaks a different language. As people have talked about here today, the courthouse is a democratic stage. It's the place where people come for redress. It's the place they come to seek the court's help. And public confidence in the system of justice erodes if the public thinks we have two systems, if the public thinks there's one system for one person and another system for another. We simply can't have that. None of us are above the law. None of us are beneath it. We're all accountable to it. The second part of it is transparency. And for that, I believe it's openness, it's sunlight, it's shining a light on the court so that there are people sitting in the gallery who can understand what's going on, know what's happening in their community, and can understand the court's ruling. And for transparency and fairness, those are the things that I've tried to do as a public defender and as a prosecutor. When I was a public defender, a large part of my job was giving voice to my clients whose voice might otherwise be denied to them. And that's the same part when we're interacting interacting with victims. We're bringing their story to the court. So for me, it is fairness and transparency.
Thank you, Ms. Pather. Ms. Anthony?
To me, the two most important qualities in a circuit court judge is the ability and really the willingness to listen and the ability to be decisive. Those concepts encompass a lot of different aspects in a judge. When it comes to the ability to listen and the willingness to listen, to me, that speaks and strikes to the heart of what we care about in our justice system. It really is justice. The idea that everyone is fairly treated under established rules and laws. And in order to do that, you have to have a judge who's willing to listen to all reasonable arguments and inspect all relevant law and apply it to the case, and have a ability and willingness to do so, even if there is a line of cases behind this one, or even if there are other people who want redress in front of the court. The court needs to be able to take each case as it comes and give it the proper consideration and faithfully discharge its duty to the parties at bar. One of the things that I pride myself on as a prosecutor throughout my career is the ability to do just that. We are faced with prosecutors all the time with individuals who come to us either as victims, but also as defense attorneys, and sometimes even as defendants, certainly pro se defendants. And the ability to listen, the ability to take a phone call, to listen to someone's side is incredibly important, and I do that every day. The other important quality of a circuit court judge is the ability to be decisive. Many times you hear attorneys say that they'd rather have a case decided wrongly than not decided at all. And I think the ability to give a final decision rather than leaving parties in limbo is incredibly important for a circuit court judge, and is something I have to do as a prosecutor every day in terms of making decisions that might impact other people's lives.
Thank you, Ms. Anthony. So, Ms. Pather, you will lead us off in the next question. Given that your legal career has focused mainly on criminal law, what challenges, if any, do you anticipate in hearing civil cases, both substantively and procedurally? And how do you plan to address those challenges?
Thank you. So I think for all of us, we don't have a lot of civil experience. As a prosecutor, I am required to have a working knowledge of civil law as it relates to an overlap in some of my cases. Those include protective orders. Those include child and abuse and neglect cases. For protective orders, I need to know about the overlap with them in domestic violence cases because of the content of them, the service of them, and what the violations can be as a result of that. For child and abuse and neglect cases, I screen all of those cases when they come into our office from mandated reporters to make sure that they comply with law, and then I assign those cases. In order to do that job, I have to know the workings of the Department of Social Services, Child Protective Services, and how they can act. I also serve a similar role in our office of screening all the Title IX cases from the University of Virginia for felony sexual assaults. That also involves a knowledge of Title IX regulations such as FERPA, Clery, to make sure all the regulations were followed and that it's compliant with state law before I do those cases, and I'm the primary prosecutor. So I do have a knowledge of that. I would say, like, I think we all would say when we start out, there's a steep learning curve for anyone going into a new practice, but the court has to be nimble. The court has resources at your disposal. And I think one of the skills of a circuit court judge is having legal acumen, having intelligence, having the ability to look at different cases and understand the case law, understand the procedure, and understand the substance. But certainly in that respect of civil practice, I would be at a deficit and would have to learn on the job.
Thank you, Ms. Pather. So, Ms. Anthony, your same question for you.
So despite the fact that I have not worked in a firm, for example, that specializes in civil litigation, the skill set that is required for a judge who is presiding over civil cases is the same skill set in a lot of ways that a judge would preside over a criminal case. When I think back to how I frame what a good judge is, it goes back to intelligence, to fair-mindedness, to patience, how somebody addresses and listens to the litigants in court. And all of that is across the board, whether it's a civil case or whether it's a criminal case in front of a court. And so I think that the qualities that I bring to the table, which allow me to listen fairly to both sides of an argument and render a decision based on the facts and the law, would be equal in civil and criminal cases. I think there's no question, and I certainly can't say that I have the civil background that other attorneys might have. However, one of the things that's pivotal for a judge in any respect, because no judge comes to the bench with a deep understanding of every aspect of law that he or she will see. But they need to rely and be willing to be humble and rely on the litigants to help educate themselves, and to be willing to put in the hard work to educate themselves outside of the courtroom, to whether that's spend long hours at night or on the weekends doing research into novel issues that have not come before that judge in the past. That is something that I think is important, and something that a good judge is willing to do, to put in that legwork in order to get up to speed. And that's something that I think that I would be able to overcome, despite the fact that I don't have the traditional civil background.
Thank you. Ms. Hakes?
I actually do have a fair amount of civil experience. It's not what I'm known for. As I have matured in my career, I've done more and more criminal defense, and that's sort of what I have become known for in the community. But as I mentioned in my opening statement, during the first half of my career, I did a lot of different civil litigation. I filed suits at Law and Equity when that used to make a difference. I've taken depositions. I've, fought the fights of civil discovery. All of that stuff I have done, not in every imaginable context, right? I mean, the one thing you can say about people who want to be circuit court judges is the people who do not want to be circuit court judges are the circuit court judges, right? People who are already circuit court judges are not trying to be circuit court judges, right? So you're always going to have candidates who have not done everything that the circuit court handles. I mean, nobody can do everything. But I do have a fair amount of significant experience to draw on. Might have to blow the dust off of it, but I've done it. I know how to do it. And B, I can learn. I mean, that's the thing. I'm not afraid of hard work. I am an attorney who works pretty hard. And just like I taught myself once the Virginia Condominium Act in order to litigate that case however many years ago, I think I can teach myself the areas of civil practice in which I may be deficient.
Thank you very much. All right. We're going to start off with Ms. Anthony again. What experience do you have in understanding physical or psychological trauma in your professional life, and how will that experience inform your practices as a judge?
The effects of psychological or physical trauma is something that we are starting to understand slowly, and I feel as legal practitioners still have a deficit in terms of understanding the true effects of trauma on practitioners and the people around us, the litigants that we see in court. When I think of vicarious trauma, what I think of is the numerous trainings that I've been to in this field. But one of the things, and I in no way want to be flip about this because it is a very incredibly serious thing, but when people ask what is vicarious trauma, how do I understand that? How do I explain? Sometimes you can think of a movie like Home Alone, where you see something happening to somebody, and what happens when that person steps on the nail? You can't feel it, but you wince, because as human beings, we internalize what is happening to others. And that's a silly and almost dismissive way of explaining vicarious trauma, but it's a simple one that everyone can understand. And I think it's one that litigants and judges need to understand when they're looking at cases and when they're looking at the types of cases that come in front of us, because those are things that we have to deal with. And if you allow it to and don't address it, it can consume you. I have had the experience of trying significant traumatic cases, including the prosecutions of the offenders who came to commit violence against our community on August 12th, and reliving those moments, reliving that through 18 months of memorizing videos for those instances took a toll on me. It frankly stole pieces of my soul I'll probably never get back. But recognizing that is the first step in being able to deal with that and not letting it affect how you interact with individuals in your lives and how you allow it to make you a better attorney in the end.
Great, thank you. Ms. Hakes?
I've done a lot of awful cases. And so I know a fair amount about the science of trauma, just from having to prepare those cases and having to call experts or having to cross-examine experts. What I would say is, we have come to understand that trauma or traumatic experiences can produce physiological effects, right? You can have neurological effects from trauma. I think it is important for a judge to remember that in evaluating evidence in a case, right? So let's say, for example, a witness says, describes what happened, and then later, a month later, a week later, describes what happened in more detail, right? Well, sometimes the talking about something can help sort of loosen some of that up, and you may recover some additional details about something. I think it's important, however, to remember that those effects are not entirely unbound. If a witness says X happened, and then you get to trial a year later and the witness says not X, it was Y, I think we have to be careful not to exaggerate the effects of trauma into a point where our ability to judge credibility is completely crippled. So I think it's very important. I think it's important to understand how it works, and I think there are limitations on it.
Thank you, Ms. Hakes. Ms. Pather?
Thank you. So as prosecutors, we see people dying in videos. We look at autopsy photographs and we see the physical trauma in murders. We see it in sexual assault cases. And in the cases that I have done for our victims, long after the physical trauma heals, the psychological trauma continues. And I don't think we talk about trauma enough as a community. I think trauma is the answer to so many questions that we have. We learned about ACEs, adverse childhood experiences, and how we can build resiliency. And I think that is a key part for the courts to understand, that defendants and victims are coming to the courts and they might have adverse childhood experiences. And we need to learn how as systems we can build resiliency and help them in those situations. I think there is the neurobiology of trauma, which is what happens to survivors during any kind of traumatic incident. And that could be a car accident, that could be a sexual assault, that could be a violent crime, but that's part of the understanding that we need in this case. And then the other part about it is secondary trauma. We don't talk about that enough. Our juries sit in jury trials with homicide cases and sexual assault cases, and they're having to look at very difficult evidence and process it. And they suffer a secondary trauma, and so do we as practitioners. And so something that our office has worked on a lot is how do you build resiliency into all of these things? Because psychological trauma is there. It's there for our survivors. It's there for our defendants. And I think the court system is uniquely positioned to understand that and to build resiliency and to help put a footing under people. And that starts from understanding the neurobiology of trauma when an incident happens all the way to when the court is sentencing somebody.
Thank you. All right, Ms. Hakes, you will start us off with the next question. What do you see as the biggest barriers to pro se litigants effectively accessing and using circuit court? What role should circuit court judges play in making sure trials are conducted fairly for all litigants, especially pro se litigants who may not be familiar with procedures and substantive law?
Well, I would say the biggest barriers for pro se litigants in circuit court are similar to the biggest barriers in any kind of district court. They're just exaggerated further by the formality of the proceedings. I mean, the law can be Byzantine. And there are, lawyers have learned a whole nother language. We've learned to swim in this particular arena. And lay people, not so much. And so I think, one of the big barriers is just understanding what's happening. I think that especially, if you're pro se and you're in a circuit court tends to be fairly formal, you could have a deer in the headlights kind of experience to begin with. And then you don't really understand who all the players are or what's happening or what the rules are. I think that's a problem in any court, but more so in circuit court than in the district courts, which tend to be a little less formal. I think that it is incumbent on a sitting judge to try to accommodate and explain what is going on to a pro se person. I think that it is important to be patient. And I think there should be some flexibility there with regard to a pro se person. Now, that flexibility cannot be so much that it changes the outcome of the case. You can't just say, well, you're pro se, so I'm going to give you the benefit of the doubt here. But I think you do have to try really hard to accommodate those people, because what people think of their judicial system matters. It matters to the judicial system itself. It matters to the stability of our society.
Thank you. Ms. Pather.
Thank you. I think some of the barriers for pro se litigants in circuit court are the procedural barriers. So filing motions before the court, how to docket those motions, how to get them before the court, how to do them in a timely manner, how to know the deadlines that are approaching for a case. There are also other procedural requirements like sending out subpoenas, how to navigate all of that. And the court sees that from pro se litigants, from someone there on a traffic ticket to someone representing themselves on a murder case. I think, as we all will say, the substantive law and the procedure applies equally, but especially when there are barriers to the person understanding, the court should take more latitude with that person to make sure the court is being clear and concise in your rulings, to make sure that the person understands objections, and also make sure that the person is getting the chance to be heard. I think the court has another responsibility to make sure that the represented party is not taking advantage of the pro se party, and that the court is not receiving inadmissible or irrelevant evidence because someone is trying to game the pro se party. I think what the barriers are barriers in access to justice. And for anyone who's there representing a traffic ticket or a murder case, all of those cases are so important to the person, and they have the right to be heard. So I think the court can be clear with the person in terms of what the deadlines are, what is incumbent upon the person to file, what is coming up in the case, what is expected. And I think the court can certainly take more latitude in explaining the case to the pro se defendant, the litigant.
All right, thank you. Ms. Anthony.
Unless the pro se litigant is themselves an attorney, the barriers are, frankly, as my other colleagues have discussed, it's the understanding of a pro se litigant to engage in a system with different rules, different language, different concepts than they may have been familiar with ever in their lives. And what is important at the end of the day is that in order for our system of justice to work, every person, including a pro se litigant, needs to be able to leave court feeling like their case was heard. And so a court's role, especially in circuit court, is balancing that fairness on both sides. With a pro se litigant, substantive law has to apply equally to all sides in order for fairness to achieve any real meaning. But I think some procedural safeguards can be relaxed in the sense that a judge can take extra time to explain things to a pro se litigant that they may not explain to a practicing attorney. Explain how to file a motion, maybe to give some guidance in a resource that they might consult. Certainly not give legal advice, but take time and care to explain what is happening in court so that the pro se litigant has a chance of understanding the outcome and a chance of understanding the process on which they're engaging. one of the things that is often important with the pro se litigant, and often something that is deficient with some courts, is that when we have pro se litigants, they often come to court without that knowledge base, and it can be a frustrating experience, not only for them, but the other litigants and the judge. And so patience is of paramount when a court is dealing with a pro se litigant. And so making sure that their rights are respected is important when dealing with a pro se litigant as well.
Thank you. All right, the next question will lead off with Ms. Pather. What role should circuit court judges play in reducing barriers to court access, such as poverty, language ability, and disability? What role should judges have in encouraging pro bono services?
Thank you. So the judicial canons are clear on that the court should encourage pro bono service in those areas that were, I'm sorry, could you repeat the question again?
Certainly. What role should circuit court judges play in reducing barriers to court access, such as poverty, language ability, and disability? And what role should judges have in encouraging pro bono service?
So I've answered the pro bono service part, that the canons are clear that the court should engage in that and can specifically talk about pro bono service as being a service to the community. I think access to justice is the most important part, and language is important. Everything that makes one person different has to be considered by the court. And that starts with having interpreters, and not just an interpreter which are language, so that the person can understand. Because if you are in a country and you don't understand the language, you're at a huge impediment, especially in our circuit court where the stakes are so high. So that is access to meaningful justice. And that's the same with disabilities. We've got new laws that were passed last year, thanks to Senator McClellan, where evidence can be put on for an expert in terms of developmental conditions. And so that can certainly come before the court. The court also has to be adept at understanding where people are and where they sit. And so, one example is sometimes plea agreements can call for someone paying restitution up front. But when I was a public defender, my clients would not ever be in a position of paying $500 or $1,000 up front for a plea agreement. So the court has to be nimble, and the court has to understand where people are coming from. And I think the greatest thing that the court can do is take access to justice seriously by making sure that everyone is coming through and everyone is having an opportunity and a voice to be heard.
Thank you. Ms. Anthony?
The ability to have access to justice is paramount for our system to function properly. We need to be able to allow equal access across the board for all people to seek redress in front of the court. The court's role in in reducing some of the barriers to access, poverty, language, needs to be such that it makes it easier for people to access those services. Specifically, when we're talking about poverty, there are ways in which the court can waive fees, filing fees, can allow in indigent cases the appointment of experts, to allow funds for experts so that individuals, regardless of income, regardless of financial condition, can afford the same type of justice and defense that somebody who might have significant more resources is able to bring to bear to court. With regard to language ability, it is incumbent upon the court, whenever there's any indication that someone might not be understanding what is happening in court, that the court pause and take a moment to fully explain the matters, and if needed, get any interpreter that is required. There have been multiple instances in court where we've had to stop proceedings and find interpreters and realize halfway through that the individual spoke a specific dialect that maybe that interpreter didn't understand or wasn't actually speaking. And that is incumbent upon the court to take an active role in understanding that, because it ultimately stops at the feet of the judge to make sure that everyone is heard and understood when they're in the court.
Thank you. All right, the next question, you also will.
You're gonna let me talk about
me?
That's not fair. Yeah, wait a minute.
Ms. Hayes.
All right. So I think that the court's job is to set a floor on these things, right? I mean, there's certain access, certain accommodations which must be provided. You cannot try someone in a foreign language they don't speak. That is just not how our system of justice works. Obviously, someone who has a hitch in their get-along may need some physical assistance getting to the courthouse or into the courthouse or the right seat in the courthouse. And those things are at a minimum, right? I mean, these things are required by our laws. And I think that at a minimum, a court must provide those things. A circuit court judge must ensure that those things are happening. I think that beyond that, to the extent that the court is able to engage in educational programming, to engage, to engage with the community, with the legal community, trying to get people to volunteer to represent people, things of that nature. I mean, I think that is great, and it is something a circuit court judge should do, right? A circuit court judge should encourage us all to step up and try to assist in those ways. But the circuit court is not going to solve poverty. The circuit court is not going to solve all of the ills that exist that create these barriers. So I think there is a role beyond that floor, and that role is, as an important part of the community to try to better those things. The canons talk about it. They basically say judges can do things. They limit what judges can do, but they can do things to improve the quality of justice. And so I would say that is definitely something that a circuit court judge should do. It is not the end-all solution.
Thank you. Sorry. Skipped over you there for a moment. So Ms. Anthony, you have the next question. Describe your understanding of the judge's role in managing and scheduling the court's docket, and what your approach to docket management would be. What, if any, responsibility does the circuit court judge have in ensuring that all litigants have timely access to the courthouse?
Can you repeat that question just so I make sure I have all of it? Thank you.
Describe your understanding of the judge's role in managing and scheduling the court's docket, and what your approach to docket management would be. What, if any, responsibility does the circuit court judge have in ensuring all litigants timely access to the courthouse?
I think at the end of the day, the concept of timely access to the courthouse starts and stops with the circuit court judge. At the end of the day, the circuit court judge is in charge of the administration of the docket and is in charge of making sure that the cases are heard timely, that the dockets are run efficiently. And so I think a circuit court judge does play a role and should play an active role in the management and scheduling of the docket. That's not to say they need to be the timekeeper, that they need to be the only person with the scheduling book. But I think that they need to be intimately familiar with how a court is being run in terms of what is being scheduled, and demand from the litigants accurate information and estimates on how long a matter might take. We have all been in court in a situation where a hearing that was scheduled for 30 minutes on a crowded docket suddenly turns into a 2 or 3 hour hearing. And it is incredibly frustrating for the court, for the litigants, for everyone who is now waiting for their turn to be heard in front of the court. And I think it's incumbent on the court to make sure that that happens very minimally, and it happens in the extraordinary case. What I would do is try to think through how best to segment the docket to run as efficiently as possible. We have, sadly, a limited resource in this community and in the 16th Judicial Circuit, and sometimes cases are waiting a year, 2 years, 3 years, especially in civil cases, for their time to be in court. And I think active docket management and scheduling cases on certain dockets, like a probation violation docket, where you can run through efficiently cases, or an arraignment docket, where you can schedule things one after another to maximize the court's time, would go a long way to increasing the efficiency of the court system.
Thank you. Ms. Hakes?
Well, I've never managed a docket before, but I managed a calendar. And what I would say is you have to build in a little bit of time for that case that's going to take a little longer than you think it's going to take. The other thing I would say is, you set some parameters, such as, it will not take longer than X days to get a hearing on this kind of case, right? You set some sort of rules in terms of what you want to have happen. But I think you also rely on the people who work in the clerk's office and the assistant to the judge who has the calendar to do their jobs. You sort of work with them and say, this is the goal. This is what how I want it to happen. And then you don't micromanage them to death. That's sort of the way it works for me in my office. I've got somebody who handles my calendar, and we communicate about how we want things to go, and I check in and make sure things are happening the way they should periodically. But that person does their job. I think you can't anticipate every potential problem that's going to happen in a day. You can't anticipate every twist and turn in a case. You build in a little resiliency. And you also, frankly, are ready to do the work. I think the thing you have the most control over is how quickly you render a decision, right? I mean, you can always burn a little more midnight oil and get that done, just like you do as a lawyer. You got a client who, needs a response to this. Well, then you work a little harder that week to get it done. That's the part I think you have the most control over.
Thank you. Ms. Pather?
Thank you. All litigants must have timely access, because we all know that justice delayed is justice denied, and that's for the defendants, the victims, the civil defendants, and the civil plaintiffs. So we have to ensure timely access to the court. As prosecutors, we run dockets in general district court, juvenile court, and in circuit court, and they all require us to be organized, prepared, and use our time efficiently. Otherwise, we're making defense attorneys, victims, civil attorneys, and the police, and even the court sit and wait for us, and that's unacceptable. The court has a supreme responsibility to make sure that the docket is managed in an efficient and expedient manner, and the court is obligated to render timely judgments, and the court's responsibilities must take precedence over everything. I think, as my colleagues have said, the court can work closely with the clerk's office, can work closely with the judicial assistant to make sure there are not a backlog of cases that are slowing down the docket. You can make sure that when a case is docketed, it is docketed for the appropriate amount of time. I think changes that you can implement, as Ms. Antony said, in Richmond, we used to have probation violation days, and they were very helpful because all of probation would come on one day. The defendants would know that if they were being detained, they would have their case on, let's say, the second Tuesday, and it was court running in an expedient and an efficient manner. The same could be done for misdemeanor appeals cases, hearing them on the same days. I think other things that the court can do is do pretrial scheduling orders in serious cases so that the court knows when pretrial motions are coming, when an offer might be extended, when an offer might be extended and accepted, so that they're not jury trial dates that are sitting on the court's calendar and then a jury goes away at the last minute. And I think signed plea agreements before the court is also another way of ensuring efficiency on the docket.
Thank you very much. So Ms. Hakes, you'll lead us off on the next question. What are your views on whether the courts as a whole deal effectively with racial, gender, and other forms of bias, and how would this inform your role as a judge?
Well, this is a little bit of a tricky one, in particular because you mentioned the word bias, right? And the judicial canons have a lot of things to say about bias. And one of the things they say about bias is you can't prejudge things, right? So, it would not be appropriate, I think, for me to say, well, this is how, I think there's certain things you can't say in response to that question. What I would say is we have a long way to go. The pursuit of equality, justice, is just that. It's a pursuit. I think it is incumbent on a judge to try to avoid any. I shouldn't even say any. I mean, there are obvious inequities in our society. There are obvious issues in terms of access to the courts or justice or all those things. I think it's incumbent on the court to try to minimize those things. But I don't think we can resolve everything. The courts in the end, the court's bound by the law. And so if it is incumbent on the legislature, I think, to improve our laws, and then the courts to implement those improvements.
Thank you. Ms. Pather.
So Ms. Hakes is right. The judicial canons are clear on a court and bias and what the court can do. But I think it's a greater question that we are dealing with as a society. And I think a judge, it comes back to fairness and it comes down to transparency. I think, as I've talked about, people coming before the court are going to look different. There might be people who speak a different language. There might be people who are not from the United States. People might have different genders. People might have different races. And the thing that the court has to, strive for is to make justice accessible to everyone. Just because you live somewhere that is different, just because you have a lawyer, it doesn't mean that there's one system for justice for one person and one system for another person. You may look differently, but you should not be treated differently. And I think where the court can take its role from this is that the court can be humble, the court can be educated, the court can listen. I think listening is an important part, and that's something that I think we learn as prosecutors, that we don't have the answers and that we have to listen to people when they're trying to explain what is happening. And I think that's exactly what the court has to do. The court has to apply the laws faithfully, but when we're dealing with issues like this, I think it is a prime time for the court to focus on accessible justice. And how the court does that is opening the courthouse doors so that people can come through, whether or not they speak a different language, so that they can have an interpreter. We can make sure that attorneys are assigned if people can't afford an attorney. We can make sure that everything is being done up front to make justice accessible. But I really think where it comes down to it for the court is that the court can be humble, the court can listen, and the court can be educated.
Thank you. Ms. Anthony.
We have been striving over the last decade, 2 decades, 3 decades, really, to answer how we address bias in the court system. What does that mean? What does that look like? And I wish I had an answer for what that is, but I think we're all still trying to figure that out. But at the end of the day, we have to, as a court system and as a judge in particular, impartiality of the judge is paramount. A judge has to be willing to take the case as it comes to it and apply the law fairly and equally, regardless of the circumstances and how the individuals present. However, that doesn't mean that the judge has to be unaware of maybe its own biases or implicit biases. And in fact, I think a judge has to actively strive to understand those biases in itself and to make sure that it's willing to have a frank conversation about that, to be educated by the litigants, to be educated by plaintiffs, by defendants, by pro se individuals who come before it, and to be willing to meet individuals where they are and to learn from them, and in that way, hopefully start to break down some of those barriers. But at the end of the day, it really is about keeping an open mind and the impartiality of the judicial system.
Thank you. All right, Ms. Pather, you will start us off on this one. What effects do you think incarceration has in criminal cases, both pre and post-trial? And how would you consider that as a judge? What alternatives to incarceration are most effective in ensuring public safety?
I'm sorry, could you just repeat it again?
I will. What effects do you think incarceration has in a criminal case, both pre and post-trial? And how would you consider that as a judge? What alternatives to incarceration are most effective in ensuring public safety?
Thank you. So last year, the rebuttable presumption in felony cases was done away with in the General Assembly. And I think the first place for the court to start in bail hearings is considering the statutory factors in 19.2-120. But it's a really important time because I think the court has to see it not just from the statute, not from is there a probable cause that the person will fail to appear, or is there a probable cause that the person will present a danger to himself, the public, or family member, but from both sides of it. So for the defendant, if they've been locked up away from their family, the bail hearing is their first time in front of the judge. They might not have gotten to call a family member. People might not know where they are. So the court has to consider all the non-exclusive factors in the code section, ties to the community, the weight of the evidence, the charge itself, was a firearm used in making that decision. And I think a decision that can safely put someone back in the community where they can be working with their family is sensible. And there are lots of ways to do that in our community. We've been really lucky that we have not used secured bonds. We have just made the decision that either somebody is at a risk of failing to appear, at a risk of public safety, and they will be detained, or they will be released. OAR is a great community service-based provider to help people with pretrial services. So I think looking at that from the perspective of the defendant is really important. I think there's also the perspective of the prosecutor in those bail decisions. I think also what systematizes it for the court is the VPRA. So I'm running out of time. So alternatives to incarceration. So again, we are so fortunate in our community, and we're lucky that our judges consider all alternatives to incarceration. And those could be home electronic monitoring from the jail. They could include work release. They can include community service. And all of those are very safe and effective ways of keeping someone in the community working at home with their family, but also ensuring public safety.
Thank you. Ms. Anthony?
When I think about the effects of incarceration in a criminal case, both pretrial and post-trial, I think it can't be strongly enough stated that incarceration really should be the last resort. And I know that's coming from a prosecutor, but the effects of depriving someone of their liberty, certainly pretrial and post-trial, should be used and reserved for those cases where public safety demands that that individual be removed from society for some period of time. And I think it's something that the court has to weigh very carefully. It has to look to whether, as Ms. Pather mentioned, that individual pretrial would be a danger to themselves or others, whether they are a risk of failing to appear. And if those conditions are not met, release should be what the court strives for. When I think about internal alternatives to incarceration, especially in the context of increasing public safety, I often think about that dichotomy of what a crime is versus, I often think about treating how you treat someone fairly, but also keep the community safe. And this is a balancing act that prosecutors have to do on a daily basis. One of the things that I've found is that the use of alternatives to incarceration, especially when you have a case where the offense might be something that doesn't have direct harm to a human being or a direct harm to an identified victim, that is something where alternative to incarceration may be incredibly appropriate. therapeutic docket, drug court, treatment programs, things that do not necessarily take an individual out of their environment and put them in a institutional environment like a prison or a jail. And I think at the end of the day, that is a way to increase public safety, because those individuals will be coming back to the community and hopefully have resources that have bettered them and will be able to keep the community safe through that process as an alternative to incarceration.
Well, I think pretrial incarceration and post-conviction incarceration are entirely different things. I think pretrial incarceration, one of the things that's important to remember is when you lock somebody up pretrial, you really do limit their ability to communicate effectively with their attorney. You limit the ability to prepare for trial. I think if you can give someone bail pretrial, you should. We have a presumption of innocence. We have constitutional requirements that, bail should be granted, except, no excessive bail, I guess is the way it's phrased. But so I think pretrial incarceration is different than post-conviction incarceration. However, I think even in terms of post-conviction incarceration, the United States incarcerates a significantly higher percentage of its population than many other nations of similar stature. I think that's food for thought. However, I also think judges have to follow the rules. We have to follow what the legislature sets out. We have to follow the sentencing guidelines. I think that much of the heavy lifting on solving that problem, again, belongs in the political realm and in the legislature. It is more important that judges are consistent and apply the law as it exists. So while I'm not fond of incarceration and it has a lot of ill effects, it is what is prescribed in many cases.
Thank you. And for our final question, Ms. Anthony, you will lead us off.
Yeah.
What is the court's role in addressing mental illness as it affects individuals in the court system, both criminal and civil?
I'm going to make you repeat that question again. I'm sorry, Judge Downer. I like writing things down.
All right. It's what is the court's role in addressing mental illness as it affects individuals in the court system, both criminal and civil?
Mental illness is something that we have only begun to understand in terms of the volume of individuals in our community and in the court system that are affected by a serious mental health illness. One of the things that we've done in this community, for example, to try to address the fact that there are an incredible amount of people in our justice system that are suffering from a serious mental health illness, is create a therapeutic docket that recognizes that individuals with mental health illnesses do not necessarily need to be incarcerated if they commit a crime, but rather need services, they need treatment, and they need to be able to be in a safe environment that will help them get better. The court absolutely has a role to play in that. And the court, I think, is the first place that an individual with a mental health illness or who might be suffering from the effects of some sort of mental health illness can seek redress, who can be heard by somebody who understands that what is happening to them may not be their fault, that the things that they are going through or are experiencing are a result of an illness and should be treated as such, and not the result of a defect in character or a defect in who they are as a person. So I think that the court has a role to play in acknowledging that and striving to create sentences, whether in the criminal context or in the civil context that address the fact that some behavior may be rooted in mental health illness and not necessarily the effect of bad character, and need to be treated differently than somebody who might present in a different way.
Thank you. Ms. Hakes?
In that first half of my career, when I didn't just do so much criminal, I was a special justice for a few years, and I would go hear cases at the Fluvanna County Women's Prison when they would have a prisoner who was having a mental health crisis, and they want to move them from, the regular wing of the prison to the mental health wing. I felt then, and I still feel now as an attorney who represents people who have mental health issues, that we are not doing a very good job of serving these people in our society. I used to have I've got these file cabinets in my office, and in the bottom drawer of the file, the top however many drawers are all client files, right? The bottom drawer is where I have files where I've saved documents over the years, right? Like there's one that says Fifth Amendment, right? When I get a Fifth Amendment case, I pull up my Fifth Amendment file and I look through it and I find all the old cases. I've got an alternatives to incarceration file in there too, right? And I used to have so much more in that file. When I started practicing, we had more resources devoted to this kind of thing. And those alternatives often are designed for people who have mental health issues. Over time, the funding just hasn't been there, and that file's getting skinnier and skinnier. I think the court, the court has a limited ability to address these things without some help from the other branches of government. I think that the court should do what it can. I think that we've gotten away from the McNaughton rule, right? We don't believe anymore in just insanity. That's progress.
Thank you. Ms. Pather?
Thank you, Judge Downer. I think we're lucky in this community, as Ms. Antonian said, and this is really thanks to the hard work of people in this room who fought hard to have a specialized docket here in our community. And we're lucky to have this here as in other parts of the state. And I think the Therapeutic Docket in General District Court is a great specialized docket. I think we're also fortunate for District 9 and OAR to have clinicians who specialize in treating people with mental health diagnoses so that they can tailor probation to them, as well as connect them immediately with services in the community, such as Region 10. And again, we're very fortunate to have that in the Charlottesville-Albemarle area. I think one place that the court can start is the court has the ability under the code to, if the defendant is before the court and the court has a question about the person's competency to stand trial, the court can raise that. I remember when I was a public defender representing juveniles in Richmond, there was significant concerns of competency for my clients, and the court is able to do that. I think that's an access to justice question. I think we have to talk, as Ms. Antony has said, we have to talk more about mental health, because when I was a public defender, if my clients were in a crisis, a disorderly conduct or a traffic stop can really quickly escalate to something that's violent. And we see that on the news all the time. And we have to talk more about it. And we have to talk about how our criminal justice system can be more adept to handling it. I agree with Ms. Hakes. I wish that there was a way to fund even just an across the board psychological evaluation that the courts could rely on in these cases. I think we are moving towards diminished capacity in our cases, certainly with the legislation passed by Senator McClellan last year about having an expert in terms of intent. But I think the court needs to be adept at this. The court needs to make itself an expert in seeing what is going on so that the court can respond to this.
Thank you very much. That concludes the question part of our forum this evening. And so now it's time for closing statements. And Ms. Hakes, you will start us off with the closing statement. You have 2 minutes.
Thank you all for coming here tonight to listen to all of us pontificate. These 2 ladies on either side of me are my friends. And it's just a fact. It's part of practicing law in Charlottesville, in this community, that, we go to court and we beat each other up, right? But I don't mean it, right? I really enjoyed the opportunity to talk to you guys tonight and answer these questions. But one of the things I really appreciate is that we live in a community where people are interested enough in what's happening, interested enough in their judiciary and the way the system is functioning and who's going to fill the next seat, to come up with these questions, to come out, to watch, to ask, to listen. I certainly would like to be the person to fill that chair, but regardless of whether I end up being that person or not, it is good for our local community that this is happening. It's good for our democratic society that this is happening. And I really appreciate you all giving us all your attention this evening.
Thank you. Ms. Pather.
Thank you. I too want to echo those thanks, especially the Judicial Endorsements Committee for putting this together and everyone who is spending their night watching us. I have sat in a courtroom with clients who have received verdicts of not guilty and saw their relief. I've also sat in a courtroom with clients who have received guilty verdicts and saw the reality of what was coming wash over their faces. Similarly, I've sat in courtrooms with victims as I heard verdicts of guilty, holding somebody accountable for what has happened. And I've been with them for verdicts of not guilty. The emotions are the same: fear, hope, relief, sadness. Everyone on both sides of the aisle puts all their hope and faith in the court to mend a wrong and to find a solution. And to do this, the court must undertake a solemn exercise. It must administer justice fairly and faithfully, and the court has to know what it's like on both sides of the aisle. The court must strive to make justice accessible and fair. I've had times in my life when I was an outsider, as a woman, as a person of color, as an immigrant. People might look different, but that doesn't mean that justice should be different for them. The North Star for the court must always be to pursue justice. I've devoted my legal career to public service as a law clerk, as a public defender, as a prosecutor. I believe I have unique attributes that would serve me well as the next circuit court judge. I have 18 years of trial and supervisory experience. I have tried complicated, sensitive murder cases, including homicides. I have a robust motions practice. I've worked over the last 10 years in this community to improve our access to justice and our response to justice. The court has to be an active listener, and it has to be empathetic and kind, and that is what I have learned in my jobs. But the court also has to be decisive, and that is a lesson I learn every day as a as a prosecutor, when we exercise our discretion, because it has a lasting effect of everyone involved. I believe that I have the knowledge, the temperament, and the skill to be the next judge, and it would be my honor.
Thank you. Ms. Anthony.
I also want to thank the Judicial Endorsement Committee for putting this on and echo mistakes. These are my friends who are sitting up here. And so it's been a unique and interesting experience. I have thus far spent my entire career in public service. The decisions that I've made as a prosecutor, balancing the rights of crime victims and community safety with the fair treatments of offenders, striving to find and recommend just outcomes in my cases. These are decisions that a judge has to make as well. And I've been making these decisions every single day for the last 10 years. I know that I may not have the diversity of experience in terms of area of practice that other attorneys might have. But what I lack in terms of that experience, I make up for in ways that can't necessarily be taught or learned. It is not a given that the best judge is she who has the widest breadth of experience. But it is a given that a great judge is somebody who is patient, who is intelligent, who is fair-minded, who's humble, and yet decisive. And I've proved every single day in the way I've handled my cases that I'm such a person. I have the skill and compassion to make sure that every person who would come into the courtroom, every lawyer, every client, every participant in the system would feel that they were listened to, that they were respected, and that when they left, they would feel that their case had been fairly heard. That is a mark of a great judge. I know that if I was given the opportunity to be the next circuit court judge, that I would bring to that position a passion for justice, a thirst for knowledge, and a dedication to professionalism, integrity that would only enhance the bench.
Thank you, Ms. Hampton. And that concludes our public forum, but it doesn't conclude the work of the Judicial Endorsement Committee. We have a lot more work to do because we have to not only digest what was said here at the public forum, but we are also soliciting comments from the public and anyone who wants to make a comment for us to consider. And you will have until Thursday, February 24th, to submit those comments on any of the candidates that you've seen this evening. And there's you can do that through the Charlottesville-Albemarle Bar Association website, and there's a special web address that I'm going to give you now. It is jec@caba, C-A-B-A, online.org. So I'm going to hold it up in case you're able to see it, but I don't know whether it will be far away. So it may be a way for us to put this on there, and I'm going to give it to someone who maybe has the technical skills to do just that. But we would encourage all those who have been able to listen to this tonight. And okay.
Yeah, hold on.
She's gonna zoom in.
Can you put it in the chat?
Chat's
You can
not.
put it in the chat.
Oh, chat's not
There you
working.
go.
Okay.
We'll publicly post it too.
And we will also publicly post this address for you to send your comments. It's very important that we have as wide a range of comments in order to make the very best decision on who we will endorse and rate, how we rate these candidates. I want to thank everyone who participated this evening. I want to thank all the candidates. I think they all handled themselves very well, and I really appreciate the time everyone has spent to have this program this evening. Thank you.